Dear colleagues, ladies and gentlemen, in the book authored by Professor Albert Chen, the title of the book is The Changing Legal Orders in Hong Kong and Mainland China, Essays on One Country, Two Systems, which has just come out from the City University of Hong Kong Press. My name is Fu Hualin. I'm the Dean of the Faculty of Law. It is my privilege and honor to chair this event. So we have three discussants. Let me just introduce them very briefly. Ms. Cora Chen, Associate Professor of Law at the Faculty of Law, HKU. Professor Zhu Guobin, School of Law, City University of Hong Kong. He's also the director of City University of Hong Kong Press. He's the person who makes this event possible. So thank you, Guobin. Finally, Professor Pijin Yap from Faculty of Law, HKU. He's joined the event online. So that's what we're going to do. We have 1 hour. I'll first invite the author, Professor Albert Chen, to make a very brief introduction of the book in about 10 minutes. And then I would invite Cora, Guobin, and PJ to spend 10 minutes each on the three different parts of the book: Hong Kong, China, and Asia. Hopefully, we would have some time for discussion. Without further ado, I invite Albert to make his remark. Albert.
Thank you, Hualin. Welcome to all of you to this lecture theater in our law faculty, and thank you for attending this book launch. Thank you to those of you attending in person as well as those online. So first of all, I would like to express my gratitude to Professor Zhu Guobin here. He is the director of the City University Press, City University of Hong Kong Press. And without his steadfast moral support and strong encouragement, the publication of this book would not have been possible. Professor Zhu is himself a distinguished scholar of Chinese law, and under his able directorship, the City University of Hong Kong Press has become a leading academic publisher, particularly in the fields of China studies and Hong Kong studies. For example, City University Press has in recent years published many Chinese books, academic Chinese books on the Hong Kong basic law, and I actually consider them essential reading for anyone researching into this subject. In addition to Professor Zhu, I would like to express my gratitude also to Dr. Abby Mancy, editor at the City University Press, and her colleagues. They have done a very professional job in rendering editorial and administrative support for the publication of this book. And I'm indeed most honored that this latest book of mine is published by the City University of Hong Kong Press. Now, let me say a few words about the book. Apart from the preface and the epilogue, the book is divided into three parts corresponding to the three major domains of my research since I began my academic career at Hong Kong U in 1984. Part one of the book relates to the study of one country, two systems and the basic law. Part two deals with mainland Chinese legal reform and modernization. And part three is about East Asian constitutional developments. Actually, the three parts also correspond to three successive stages in the development of my academic career. When I first joined Hong Kong U in 1984, the Sino-British Joint Declaration was in the process of being concluded. And the first few years of my research as a scholar were almost entirely devoted to constitutional and legal issues arising from Hong Kong's transition from a British colony to a special administrative region of the PRC. And I also researched and wrote quite a lot in English and Chinese on issues arising from the drafting of the basic law of the Hong Kong SAR. In the early 1990s, I came to realize that in the light of Hong Kong's return to the motherland, it is more important than ever before for Hong Kong legal scholars to study and to understand the developing legal system in mainland China. So beginning with the writing of a book on the Chinese legal system, which was published in 1992, I engaged in research on various aspects of the developing Chinese legal system. Then in the course of the first decade of the 21st century, opportunities of increasing interaction with scholars of constitutional law and legal philosophy in the East Asian region stimulated my interest in the comparative study of Asian constitutional developments. As I wrote in the preface of the book, I came to realize that the case of China, which I had been studying for 2 decades at this point in time, was merely one among many Asian countries in search of legal modernization and the constitutionalization of politics. To achieve a better understanding of the current stage of development of the Chinese legal system and its possible future, it became necessary and useful to take into account the constitutional and legal trajectories of China's neighbors in East and Southeast Asia, unquote. So this kind of research into East Asian constitutionalism represents the 3rd stage of the development of my scholarship, which is evidenced in part 3 of this book, which includes, as the last chapter of the book, the text of a public lecture I delivered in 2019 in this very lecture theater, as one of the lectures organized by our faculty to celebrate our 50th anniversary. In the course of my academic career, I have written or edited more than 10 books in English or Chinese and published more than 200 book chapters and articles in English or Chinese. I believe that it is important to write in both languages. And in particular, the intended readers of my Chinese writings include not only people in Hong Kong, but those in mainland China and possibly also people in Taiwan. For readers in China, I have written mainly about one country, two systems and the basic law, and also about the relevance of Western legal and political thought to China's legal modernization and reform. The book, which is the subject of this book launch today, is in English and is a collection of some of my English writings. The book includes a selected bibliography at the end of the book, which provides a list of what I consider to be my major publications. As for the essays selected for inclusion in the book, some of them are selected because they were originally published as book chapters in volumes edited by other scholars. So they may be less accessible than my journal articles in the past. That's one reason for including some of these articles in this book. Another criterion for selection is what I consider to be the importance of the topic dealt with in this in the particular essay. Now, let me introduce to you briefly the content of each of the three parts of the book. Part one begins with an essay on the rule of law developments in the Hong Kong SAR from 1997 to the end of the first decade of this century. It shows how the foundation for the rule of law in the Hong Kong SAR has been laid during this period. The next two chapters deal with the political system of Hong Kong and issues of its democratization, as well as the autonomy of Hong Kong SAR under Chinese sovereignty. These are two of the most important topics in the study of Hong Kong's constitution. The next two chapters deal with social movements and the law in Hong Kong. And they demonstrate the importance of social movements in the history of the Hong Kong SAR from the anti-Article 23 movement to the Occupy Central movement, and of course also the anti-extradition movement of 2019. Moving to part 2 of the book, the first few chapters of part 2 introduce readers to the Chinese legal tradition, including Confucianism and legalism, and it also deals with the challenges of the Chinese reception of modern Western ideas of human rights and democracy. The next few chapters in part 2 look at the development of the socialist Chinese legal system from 4 different perspectives. First, the historical perspective, providing an overview of the major stages of legal development since 1949. Secondly, the comparative law perspective, trying to locate the Chinese legal system within the great families of legal systems in the modern world. Thirdly, the perspective of property rights, looking at how contemporary Chinese law recognizes and protects property rights that are considered essential for economic development. And fourthly, finally, looking at the Chinese legal system from the perspective of law and society studies or socio-legal studies. Then in part 3 of the book, I try to explore the relationship between political systems and types or nature of constitutionalism in different Asian countries, and to develop a typology of Asian constitutional law or Asian constitutionalism. In the last chapter, I presented an overview of the constitutional journeys of 5 major Asian jurisdictions and chronicled the progress they have made in the last 5 decades. The period of 5 decades was covered because this chapter was originally, as I mentioned, a public lecture delivered to celebrate the 5 decades, the 50th anniversary of our law school here. Finally, in the epilogue of the book, I try to update readers about current developments and to share with readers my observations and reflections about current trends in the Hong Kong and Chinese legal systems. The update includes the aftermath of the anti-extradition movement and the enactment of the national security law in Hong Kong, the 2018 constitutional amendment in China, and also President Xi Jinping's project of ruling the country according to law. I also discussed the issues of rule of law or rule by law in China, and the prospects for socialist constitutionalism in China as advocated by some scholars. All in all, this book can be regarded as an attempt to provide a macro-historical perspective for the study of legal and constitutional developments in Hong Kong, mainland China, and East Asia. As I wrote in the epilogue, and I quote, this book is titled The Changing Legal Orders in Hong Kong and Mainland China, with the emphasis being on changing. Change is inevitable in legal orders as it is in all human affairs. This book seeks to explore such change in its historical, political, and social context, not only for the purpose of understanding the nature of such change and the reasons behind it, but also to situate the present circumstances within history and to ponder future possible trends, unquote. In the final analysis, I think the 3 domains of my study, as presented in 3 parts of this book, are interrelated. So may I close by quoting from the last paragraph of the epilogue of this book. There appear to be more similarities and differences among societies, peoples, and nations in the contemporary world. Although each has its own historical trajectory, there are numerous political, economic, and social forces and dynamics that operate similarly almost everywhere in the world. Just as there are universal aspirations of humankind that have found increasing degrees of expression and recognition through globalization. Legal orders and the societies they serve are never stagnant. Social and legal change will never cease. How and what changes will occur will depend on the operation of these forces, dynamics, and aspirations in the years to come. Thank you.
Thank you, Albert, for this introduction. So now I would invite my colleagues to make short comments on different parts of the book. So the book, as the title says, is about change. But for me, when I got a chance to read a part of it last night, it is also about continuity. So I would invite the commentators to reflect on this tension between the imperative to change, and of course the question is to change to what's the direction, to which goal, and also the imperative continuity in Hong Kong, China, and globally. So may I ask Cora to start?
Thank you very much, Hualing, and thank you, Albert. I have gained tremendously from your work and mentorship over the years, and it's a real honor to be able to celebrate your book with you and other colleagues on this particular occasion. I'm going to speak on part one of the book, which focuses on Hong Kong. The 5 chapters of this part tell the story of the first 20-odd years of the implementation of China's one country, two systems policy in Hong Kong. Through these 5 chapters, Albert reveals the contradictions, tensions, and ironies in the one country, two systems model, but also where its potential lies. These chapters are but a small sample of the rich corpus of work that Albert has done on Hong Kong constitutional law, but they are representative nonetheless, as they embody some distinctive features of his scholarship. Albert is not just an outstanding constitutional lawyer, he's also an excellent historian. He reasons cautiously and cool-headedly from facts, and his first mission for every study is to discern in an impartial manner what the facts are. You may think that this is a pretty basic requirement of scholars, but over the years, I've come across a lot of work that seeks to elevate one of many possible interpretations of facts as the only possible interpretation of fact, without even mentioning that it is just the author's interpretation, one of many interpretations of facts. That doesn't happen in Albert's work. Albert is always very fair to the truth. This book very much reflects Albert's research orientation, which aims at, I quote from his preface, an objective study of relevant legal developments, unquote. It is a record imbued with an objectivity that is so needed, but so rare in this deeply polarized world in which even the most basic of facts can be contested. No salient detail escapes his attention. Albert's meticulous methodology enables him to detect nuanced similarities and differences. He weaves arguments that not only are theoretically elegant, but also fit reality. In chapter 2, for example, he sets out the positions of the Chinese government and the pro-democracy camp on political reform and explains why they came to be so different, thereby allowing us to appreciate the inherent difficulty of implementing one country, two systems, a model which, according to Albert, on the one hand, nourishes the democratic aspirations of Hong Kong people, but on the other hand, vests sovereignty in a one-party regime that, I quote, must resist Western-style liberal democracy in order to survive, unquote. Of all details in Beijing's decisions on political reform in Hong Kong, he highlights, and he did this at a very early stage, he highlighted the reference to rulers having to be patriots. This, to Albert, is the heart of the matter. He observes that the various restrictions Beijing imposed on universal suffrage are but institutional safeguards designed to ensure that the CE would be a patriot. Unlike the pan-democrats, for Beijing, universal suffrage is, I quote, not an ultimate value in itself, but a means to achieve the end of selecting a suitable patriot for ruling Hong Kong. Albert diagnoses constitutional issues in a holistic manner. He takes, so for people who've seen Chinese doctors, you know what I'm talking about. He takes a Chinese doctor approach. He's able to see connections between various aspects of Hong Kong's constitutional landscape. For example, he discerns a connection between Beijing's degree of involvement in Hong Kong affairs and the nature of the political system prescribed for the city. I quote, "Ironically, the central government is politically compelled in coordinating the pro-China camp because of the inherent weakness of the executive-led government in Hong Kong. There is no ruling party, the CE lacks popular mandate, and there is no guaranteed secure or stable support in the fragmented legislature for the executive government." He also argues, I quote, "Paradoxically, there might be a connection between the limited democracy within Hong Kong's political system and the huge scope of Hong Kong's autonomy," unquote. Another feature of Albert's scholarship is that he draws on theoretical resources from an array of fields, an approach that speaks to the cross-disciplinary nature of constitutional law. This method not only introduces new and stimulating resources for conceptualizing Hong Kong's constitutional developments, but also enables scholars working in those other fields to benefit from examining legal developments in Hong Kong. For example, Chapter 4 draws on theories on social movements, such as the resource mobilization theory, political process theory, and discourse theory. It also draws on ideas in politics. I was very much enlightened by his discussion on patron-client politics and the crisis transformation perspective. A related point is that his scholarship is conceptually very tidy. With his clarity of thought, he's able to identify trends and broader themes that underlie various developments and come up with illuminating categorizations and taxonomies. For example, in Chapter 1, he divides Hong Kong's constitutional history between 1997 and 2010 into 5 stages: confrontation and adaptation, elaboration and consolidation of rights regime, the Article 23 saga, and finally, active exercise of judicial power. I do wonder how Albert would characterize constitutional developments in the last 10 years. My own view is that Hong Kong has gone from an era of judicial activism to one of bifurcation, resembling the idea of the dual state, which Professor Fu Hualing used to analyze the Chinese legal system, and which Albert also refers to in his epilogue. Chapter 4 examines the relationship between law and social movements in Hong Kong by assessing how much legal space there is for social movements, how the law has been used as a resource for by social movements, but also how the law itself has become an arena of struggle for social movements. Albert concludes in that chapter that there was still substantial legal space for social movements in Hong Kong, and that litigation was an effective strategy for social movements. Those assessments were made in 2017, and I wonder whether your assessment has changed given recent events. A final feature of Albert's scholarship that I wish to highlight for now is that his instincts as a historian and comparative scholar have led him to situate developments in context, to be able to put things in perspective. And this, in turn, has enabled him to have continued faith in the unprecedented project to preserve a liberal subunit in a socialist party state. For example, whilst realistically acknowledging the challenges facing the project, Albert observes that Hong Kong still enjoys considerable autonomy. In Chapter 3, and I noticed that the chapter has been updated to take into account recent events like the oath-taking interpretation and the inception of the security law. In that chapter, Albert remains of the view that Beijing is by and large restrained, and that Hong Kong's systems are ready and still, I quote, represent a significant break from the CCP-led political and legal system in mainland China, unquote. He views the one country, two systems journey as an experiment, which by nature is full of trials and errors. Hence, he wrote, quote, "By trial and error, episode by episode, sometimes painful, sometimes joyful, we've gradually mastered the legal art of the practice of one country, two systems. Tuition fees have been paid, lessons have been learned, history has been written. It is a history that the people of Hong Kong have participated in making." To conclude, the book as with Albert's other distinguished work, is a stabilizer and a bridge for all sides in the rocky enterprise of one country, two systems. The book comes at a most timely juncture as that enterprise undergoes the toughest of strains so far, leading many of us to doubt the enterprise's viability. The project brings out a basic insight about the viability of the one country, two systems project, an insight that one can easily lose sight of in the heat of political debates, but of which Albert tries to remind us again and again in his work. That is, that the project's success depends on, I quote, the mutual accommodation and respect of Beijing's sovereignty claims and the liberal aspirations of Hong Kong people. The book's balanced account of Hong Kong's constitutional developments provides the foundation for formulating ideas on how that mutual accommodation can be attained and for forging the consensus needed for realizing those ideas. Very many congratulations, Albert. This is a masterpiece, and thank you very much. And congratulations to City U Press for the publication.
Thank you, Cora. That's wonderful. Gobi, is your take on
Thank you.
Albert's work on China?
Okay, thank you, Chair. Good afternoon. I'm pleased to speak on this occasion and in front of so many scholars and friends present here and online. Actually, I'm a graduate of Hong Kong LLM program, and I'm happy to come back home. Today, I speak in my capacity of City U Press Director, a professor of Chinese and Hong Kong constitutional law, and as a friend of the author. First, the City U Press is very much honored to have this precious opportunity to publish Professor Chen's selected works on the practice of one country, two systems in Hong Kong, and the tradition and the modality in Chinese law, and the constitutionalism in Asia. It is undoubtedly a great contribution to the scholarship and to English literature of Hong Kong and the Chinese legal system, Chinese legal studies. Indeed, Professor Chen has the expertise in a much wider range of areas. This book is just a demonstration of his profound knowledge, fine scholarship, and a solid expertise in the selected areas. City U Press is working not only with leading scholars such as Professor Chen and Professor Yashkai, who is going to publish with us later, and also with rising stars, promising young talents. Thank you, Professor Chen, for your trust in us. Second, I'm asked to speak by the organizer on the part 2 of the book, Tradition and Modality in Chinese Law. Professor Chen has chosen 7 articles representing his reflection and thought on Chinese law, precisely on Chinese legal tradition and culture, jurisprudence, socialist legal system, constitutional property right, and the human rights viewed from Chinese political and legal tradition, and a chapter commenting on Professor Zhu Suli's jurisprudence. Very interesting. I'm not an expert in the above aspect and unable to comment on each of those articles. However, we can tell that reading all the selected articles as a whole, Professor Chen is formulating his theory and reflection on Chinese law, and his understanding and discourse about Chinese legal and constitutional order, and he's actively participating in the debate on the cutting-edge issues of Chinese law. What I appreciate more in his works, research methodology, and working attitudes is the following. 1, Professor Chen is able to study Chinese law from a comparative perspective, and this is due to his legal education background and out of necessity for teaching and research purposes. He said that his research interest in Hong Kong-based law and the jurisprudence of one country, two systems led him to the area of Chinese law, and they invited him to expand the horizon to look into the legal system, legal tradition, and the culture, and the legal theory of China. 2, I want to share my personal experience of reading his works with you. very much similar to Chorus. When you read his works on both Chinese and Hong Kong legal issues, you can feel that Professor Chen always has a calm and peaceful mind when dealing with major and controversial legal issues we have been living with. When he says that his scholarship in Chinese law is, quote, based on balanced approach that takes into account the significant progress that has been made in post-Mao Chinese legal reforms, as well as the weakness, deficiencies, and the limitations in the existing Chinese legal system from the perspectives of the rule of law and the human rights. I believe it, fully agree with him. Professor Chen always takes an active, progressive, and constructive attitude to view the developments in contemporary Chinese law from the perspective of Chinese legal modernization. He may not be seen as a fervent critic of the Chinese legal system, but he has his own way to develop his version of Chinese legal theory and to understand, explain the problems and the difficulties. Needless for me to review and comment on each chapter in the book. I believe you already have or will form your own assessment after reading them. Third, I speak as a friend. We see today Professor Chen is a very successful scholar who has published so many books and articles of all kinds. And he has earned a wide reputation as a leading scholar of the PRC and Hong Kong legal system, PRC and Hong Kong constitutional law, and the jurisprudence. He actively participates in various social and political activities, and has remarkably done his part of community service. Before finishing this talk, I'm proud to say that Albert is a great friend of mine. I hope you agree. And he's always available every time I need him to speak at a conference or symposium and to contribute a chapter to a book I edit. We have been collaborating over the past many years. This field is good and comfortable. Thank you, Albert. I end my speech here. Thank you all for listening. Thank you.
Thank you very much, Gobin. Again, that's beautiful. Finally, we have Professor Yap to comment on the final part of the book. PJ, the floor is yours.
Hello, thank you for inviting me. It's my distinctive honor and privilege to be able to comment on Albert's contribution to comparative Asian law. Albert's work is very important and path-breaking for two main reasons. The first, he's one of the very few Asian public law scholars that does pan-Asian law. And what I mean by pan-Asian law is most scholars on Asian constitutional law tend to only focus on the constitutional law of their jurisdiction. And if they compare, they will compare it with the jurisdiction in which they did their LLM. But Albert situates Hong Kong, China against the Asian geographical region and sees the similarities and differences. Secondly, Albert's work is socio-legal. So he doesn't just look at the legal rules, the legal text, but he maps political behavior and political regime against all these textual interpretation by judges or as enacted as law. And in his the two essays in his book, he did just that. And I would briefly lay out his arguments. And if I may, I'll also provide some refinements to it. But I think his work has set the stage for what future constitutional research should be, is to see how we are like compared to the rest of our region and the geography. Right? So as we all know, within Asia and around the world, we tend to have liberal democracies, hybrid regimes, so semi-democratic or what I would call semi-authoritarian or authoritarian regimes. And Albert also points to the fact that, in terms of legal text, right, and he uses the taxonomy of Lowenstein, there's the normative constitution where rights are observed. There's the nominal constitution where rights are not lived up to in practice. And there's a semantic constitution whereby the constitution is merely an instrument of social control. And he maps the political regime against the legal text. And he creates a beautiful and very enlightening taxonomy for us to understand our region, and in particular, it can be transposed to the world. So firstly, he talks about category 1, which is the category of Japan, South Korea, and Taiwan, right? As we all know, these are generally the liberal democracies in Asia. But I would also like to provide a slight refinement to this. I think Taiwan and South Korea are even more unique and even more liberal precisely because they have a two-party systems where you have a rotation of political power between two factions over time. And that's why in these two jurisdictions in Asia, they are the most liberal and their courts are also the most liberal. It's precisely because of the fragmentation of political power that you see the increase of judicial power. So for example, Taiwan, under the Constitutional Court of Taiwan, became the first jurisdiction in Asia to legalize same-sex marriage. And the Constitution of Korea in 2017 removed President Park Geun-hye, the country's top leader, right, from office on the basis that the president had unlawfully allowed her close confidant to intervene in state affairs for over 3 years. Right? Even in America, the US president has not been successfully removed from office twice. In contrast, Japan has been largely controlled by the LDP. They have lost power twice, but the opposition was so weak that the government collapsed before even one term could finish. And that allows the Japanese LDP government or the party to consolidate its power over the years, unlike Taiwan and South Korea, where you see full rotation of power. Second, Albert points, he terms it category 2, which is Philippines, Thailand, and Indonesia, and he calls them unconsolidated, fragile, unstable democracies. And I do agree with his characterizations, but I would like to just provide one refinement here. Right, I would agree that Philippines and Indonesia belongs in one category. And what is unique about this category is that you have a presidential system where you have a president that once he gets into power can consolidate power easily and become and engage in some form of strongman rule. Because the political differences within the legislature is minute and they can all be cobbled to form a super majoritarian coalition post-election. And that's why you have the strongman rule under President Duterte in the Philippines, and you have the somewhat strongman rule under President Widodo in Indonesia. But this is different from Thailand. Thailand, I would put them together in Myanmar. But in Thailand and Myanmar, you have one extra political player, the military. The military in Thailand and Indonesia, Thailand and Myanmar, as recent events have shown, right, are an independent branch of government, right? And where the civilian government do not have control over the military government, the military government can easily launch a hostile takeover when they feel that their interests have been sidelined. So in Thailand, under the latest constitution, right, the military has a civilian face. The prime minister was actually the general that was in charge of Thailand during the coup. And he's an unelected member of parliament. And the constitutional court, which is aligned to the military, previously during civilian rule, had removed 3 prime ministers associated with Thaksin. And one prime minister was removed for appearing as a guest judge in a cooking show. As you know, in the military too, in Myanmar, we have seen, right, whereby when the Aung San Suu Kyi's government seemed to be winning elections resoundingly time and time again, since the 2008 election, we see the military deciding that, you know, they just decided to end the electoral game and take over. How that would transpire, I mean, I'm not sure what will be the outcome. But even prior to the hostile takeover, the fact is that Myanmar constitution, the 2008 one, expressly reserved specific cabinet posts for the military. So they constitutionally enshrine their core interests such that they can veto constitutional amendments, even during before the coup. Right? The third category Professor Chen talks about is the category of Singapore and Malaysia. He calls them semi-democracies, and they are. But I think what is unique too about Singapore and Malaysia, they are like dominant party democracies, where you have one political party that has primarily been in power since decolonization or independence. Right? Singapore has been ruled by the People's Action Party, right, since independence in 1965. Malaysia was ruled primarily by the BN coalition. It lost the recent election, but the opposition was so weak that it collapsed within 2 years. And now the current prime minister was the former deputy prime minister of Najib. Right? So in dominant party democracies, right, elections are fair, but they are not free because the electoral rules can skew in favor of the government incumbent. Boundaries can be changed before each election. The print media is controlled, assembly rights are controlled, and the courts rarely engage in the constitutional review of legislation. For example, in Singapore, the Singapore Court of Appeal has never struck down a single legislation in the country's history. Right? And in Malaysia, in the 80s, you see 3 Supreme Court judges being impeached and removed by the Mahathir government. Finally, category 4 that Professor Chen talks about is China and Vietnam. I think we know they are communist regimes. They are socialist regimes. One party rules everything. Elections are preordained. Courts have no constitutional review powers. Right? So I think what Professor Chen has done is to lay out a very insightful, helpful, and clear taxonomy of how all these political configurations maps out and how it aligns and there's a confluence with judicial power as a consequence. Right? In dominant party democracies, the hegemony of the semi-permanent government empowers it, right, to summon all the resources of the state to stave off the opposition, such that the ruling party routinely wins handsomely at the polls. On the other hand, the civilian governments, when civilian governments are faced against an independent military regime, the generals can launch a hostile takeover and they can either veto core interests, if their core interests are affected, or they can simply abolish the constitution by brute force. In communist regimes, elections are mere kabuki theater, right? All organs of the state, the courts, the legislature, the executive, the military, are all under the unyielding control of one party, right? So I think we can say that with the resilience of authoritarian regimes in Asia and their recrudescence in Europe and North America, certainly debunks the conventional wisdom, right, that Fukuyama talks about, that history will inevitably end with the triumph of liberalism. Thank you.
Thank you. Thank you very much. I think we have 20 minutes for Q&A. I don't know whether Albert have this urge to make a quick response to the comments. Probably you can do that while you answer the questions. Let me just
one or two words.
Sure. Yeah.
Well, I just want to thank all the discussants for their, studying the book and giving very insightful comments. I do not deserve some of the praises that have been spoken. I think just like other scholars, I try my best to research and to present the reality of the situation as I change it, as I see it. So yeah, I welcome questions and comments.
Right. So if there are questions from audience, please just send your question through the Q&A function. A question for me to warm things up a little bit. So you came to this university in the early 80s, 82 or 84. So that was the year the Joint Declaration was signed. In the ordinary sense, course of things in Hong Kong, you will be retiring within the next few years. So your whole life cycle is studied one country, two systems, Joint Declaration, Chinese Constitution. So how much your writing has changed from the inception towards now? I don't know whether it's right to say towards the end of it, right? Sort of like a whole cycle. I was reading your epilogue. I somehow, maybe it's just I'm biased. Suddenly I saw you are a moderate scholars all the time, right? Your criticism is very patient. Now somehow I see the sting, right? I saw a needle in your argument. So I'm not sure whether it's because of me, you were referring to my writing, or, or you become more critical than the Albert 30, 40 years ago. So that is my first question. My second question is, if looking through your crystal ball, right? I think Paul Jian just mentioned the demise of the entire liberal order, right? I remember, I think it's Karl Marx who may have said something like, all that is solid melts into air. He was referring to the liberal order created by the bourgeoisie, rule of law, freedom, rights, separation of power, judicial independence. So do you see that this larger trend? So whatever happens in Hong Kong is not just unique because of the tension with the central government, but actually is a reflection of the larger historical force at play. Thank you.
Should I take one or two other questions?
Okay. The question here is okay. When you talk about history, philosophy, in terms of when you're referring to a constitutional change, is it necessary? Are we predetermined by our tradition in designing our contemporary constitutions? Let me see whether. Okay, let me see. There are questions. Just give me a second. Right. This is a personal question. How did your membership in the Basic Law Committee change your perspective as a legal scholar? Lots of needles.
So, thank you to Hua Ling and to the other friends who pose questions. So maybe I'll answer the easiest question, which is the third one, the membership of the Basic Law Committee. Well, being a member of Basic Law Committee means that, well, I have the chance to attend meetings and to listen to the views of the mainland members of the Basic Law Committee, who are, most of them are officials, although there are also some scholars. So maybe this enables me to understand their position better, being able to listen on first hand, from what actually they said. So that may also, enable me when I do my research writing to present the position of the central authorities better or at least more objectively. So then let me turn to the second, sorry, maybe Hua Ling's questions. I think in the 1980s, when the Basic Law was being drafted, members of the drafting committee, I was not in the drafting committee, but I wrote as a scholar, I wrote a lot in Chinese, commenting on issues arising from the drafting of the Basic Law, and also studied closely the development of the draft, the successive drafts of the Basic Law. So in retrospect, I think people in the 1980s who were engaged in drafting the Basic Law and the project of designing the constitutional framework, one country, two systems, were optimistic. They have a grand vision. They believe that one country system would work, and they also believe that Hong Kong can be further and further democratized after 1997, so as to reach the goal of universal suffrage. So I think they have a very, maybe today we will look, in retrospect, we may say that they were too romantic or too optimistic about the vision of one country, two systems. And this included not only the Hong Kong members of the drafting committee, but also the mainland members, include the officials, because because these people themselves agreed to all these provisions which you find in the Basic Law now. There's no provision in the Joint Declaration that there should be universal suffrage. The Joint Declaration actually said that the chief executive can be either chosen by consultation or by election, as you know from recent comments by Mr. C.Y. Leung advocating consultation. So the Basic Law went many steps ahead of the Joint Declaration. It went much further than the Joint Declaration in providing for a constitution of the Hong Kong HKSAR, which would become more and more democratic in the course of time. So that ultimately the goal of universal suffrage would be achieved. And the Basic Law also entrusted the Hong Kong government legislature the responsibility of legislating on national security. Article 23 saying that Hong Kong HKSAR should on its own legislate on national security. So it was assumed that there would be no problem. Article 23 laws would be passed, national security would be protected, and at the same time, Hong Kong would democratize and eventually reach the goal of universal suffrage. Well, even in 1997, we still believe that this could work. And if you read this book, as of the end of the first decade of the 21st century, I still believe that it would work well. Actually, the passage which Cora quoted about trial and error, I think you quoted it from the end of chapter 1. Yeah.
Page 30.
Yeah, page 30. The past 13 years, that was 1997 to 2010, have been a learning experience for all who have a stake in the success of the model. By trial and error, episode and by episode, sometimes painful, sometimes joyful, we have gradually mastered the legal art of the practice of one country, two systems. And I think Cora probably did not quote the last few words.
Yeah, I didn't quote the last few words because I felt that it maybe you would have revised your thinking.
Exactly. So may I now read you the last few words which I wrote in 2010, because I just said that as of the end of the first decade, I was still optimistic.
Published back in 2011.
Yes. So the last few words was that It is a history, that the people of Hong Kong have participated in, etc. But I end by saying it's a history that inspires confidence about ourselves, faith in our partners, and hope for the future. So it is right that Cora did not read these words out, because she knows that I would not be saying these words today.
Just an educated guess.
Yeah. I guess just to continue the conversation, the following few questions are related.
But
right?
I haven't finished.
Oh, I'm sorry. Okay, well, let you finish I'm
only talking about, I only reached 2010.
Oh, okay, all right.
So what about now? So since we are running out of time, so may I just quote from one or two passages which shows my current views. So I just quote from the epilogue of the book, which of course was only written recently. In the epilogue, I wrote about the anti-extradition movement, and I also wrote about the situation after the enactment of the national security law. On the anti-extradition movement, I wrote, the anti-extradition movement has revealed that many people in Hong Kong, particularly young people, are dissatisfied with the policy of one country, two systems as practiced in recent years, and do not have trust in either the Hong Kong SAR government or the central government. They identify themselves as Hong Kongers rather than Chinese citizens, even consider the PRC and mainland Chinese to be an alien other. The political polarization and socio-economic problems of Hong Kong society and the contradictions between the two systems, in one country, two systems, revealed by the anti-extradition movement, are doomed to continue to plague Hong Kong. The basic contradiction is that between the aspirations for liberty and democracy on the part of many Hong Kong people and the central government's imperative of maintaining sovereign control. And I think Cora has quoted the next sentence. The paradox of one country, two systems is such that it simultaneously generates aspirations for Western-style liberal democracy, along with limits on the realization of such aspirations. The former aspirations are nurtured by the rule of law, judicial independence, constitutional protection of human rights, free press, and a vibrant civil society in Hong Kong. The latter limits are dictated by the nature of the PRC's political system and its ideology and the developing tensions between China and the US. So what about the situation after the enactment of the national security law? I would like to quote from page 392. The introduction of the NSL exemplifies a vicious cycle and increasing degrees of mutual suspicion and distrust, which have plagued the operation of one country system since the Occupy Central movement of 2014. Opposition and resistance to policies adopted by the central authorities toward Hong Kong increasingly took the form of actions which Beijing considered to have crossed the line. The central authorities responded by taking firm actions which were seen by many in Hong Kong to mean the tightening of the space for freedom in Hong Kong. For example, the failure of the Occupy Central movement to secure what its proponents considered to be genuine universal suffrage gave rise to calls for Hong Kong independence, as activists lost hope of achieving genuine universal suffrage in Hong Kong under Chinese sovereignty. Improper oath-taking by pro-independence legislators in 2016 led to NPCSC making an interpretation in the course of the litigation related to the disqualification. In the anti-extradition bill movement of 2019, activists were not satisfied, and this is an important point. Activists were not satisfied with the indefinite suspension and subsequent withdrawal of the extradition bill, but continued to engage in protests to express discontent. Unfortunately, or tragically, this social movement, using both peaceful and violent actions to fight for liberty, governmental accountability, and democracy in Hong Kong, ultimately backfired and only had the effect of prompting the central authorities to impose even tighter control on Hong Kong by means of the NSL. So that is the situation we are in today. Finally, for the second question, history and philosophy and so on, I think it is important to understand and to study Chinese history and the tradition of Chinese political and philosophical thought in order to understand the situation which China and Hong Kong are in today. But I don't think that everything is predetermined by history or tradition. I still believe in human freedom, human beings making history. But history is a matter of contingency to some extent. I often give the example, if there's no Chen Tung Kai incident, there would not have been an extradition bill, and there would not have been anti-extradition movement, and we would not be in the situation we are today. And somebody responded by saying, yes, if the Archduke of Austria were not murdered, assassinated in 1914, there may not have been the First World War. And you know how many people died? Millions of people perished in the First World War. Anyway, so that is my view of the contingency in history, but also human freedom to make history. But of course, those who can make history, not everybody can actually have an important role in making history. But there are some people who did, like Deng Xiaoping did, Mao Zedong did, Gorbachev did, Putin did, and so on.
Thank you. I think we have passed the hours, I think. So let me just say a few words. First of all, thank you all for coming to this book launch. We all learned a lot from Albert and his writing. We are here together, or gathered here to celebrate Albert's scholarship. I tried to refrain myself from saying too much about this book because I was thinking Albert will have to write another book about the post-national security Hong Kong and the future of one country, two system, and the continuation of Hong Kong's liberal order, moderated by the Chinese tradition, Chinese culture, of course. That's the only order we know of. It is a very good order, and it's worth maintaining and worth fighting for. So I hope Albert will continue to lead us in this academic inquiry, leading to the realization of one country, two systems as it was originally understood many decades ago. So on that note, thank you very much for your contribution, and thank you for your participation. Thank you.
Okay. Thank you to all of you for coming. And